People X Rel Khan v. Maginley-Liddie.
Good afternoon. May it please the court, Hannah Khan on behalf of Diego Guerra. May I reserve 3 minutes for rebuttal?
Of course.
In a single sentence, the lower court remanded Mr. Guerra after his conviction was reversed. And even as we speak now, he is unlawfully detained in Rikers Island. The court gave a very boilerplate generic statement that failed to explain the basis of its determination and choice of securing order.
Well, hold on a second. Remand was permissible under this, under the bail laws, correct?
Well, remand is permissible for a qualified offense, but I don't think it was permissible here because I don't think there was a determination that remand is what was necessary to assure Mr. Guerra's return to court. And that's what's required for a lawful detention. There is nothing on the record to suggest that, and importantly, the court's securing order doesn't explain the basis, and so there is no lawful basis for which to detain.
So if we
Mr.
agree with you, what would happen? What do we do?
Well, I think that habeas allows only one option, and that is release. When someone is illegally detained, the only remedy under habeas is his immediate discharge.
To the extent we have concerns, you identify concerns about the failure to provide an explanation, why would this be resolved under 710A instead of 710B? Why would that not then be an abuse of discretion under B as opposed to something that is illegal under A?
Well, I think it's because, so the discretion comes in paragraph 4 of 51010. You know, it gives the court discretion in applying this and deciding a securing order. But before we get to that discretion, we have paragraph 1 of the law. And that gives a requirement to the court of these 3 things, you know, individualized determination, choosing the correct securing order, and then explaining that on the record. And so I think that before we get to discretion, we have to ensure that the correct analysis was conducted to begin with.
So is your view that the only way in which a court could examine the sufficiency of an explanation would be under A, not B? So could if there's an explanation that is not sufficient, is that something that can never be an abuse of discretion?
No, I don't think so. I think that if you had, you know, some explanation that just didn't fully justify, that could be an abuse of discretion. Here we have no explanation. And even if this was analyzed under the abuse of discretion, we still have an illegal detention here because this was an abuse of discretion.
So if we were to grant the habeas petition and agree with you he's got to be released, can the people then go and attempt to get a new bail determination?
Absolutely. Under 510.10.6, they absolutely can apply for a new securing order, and hopefully then that securing order would be constitutionally and statutorily valid. You know, hopefully that then if it went back to Justice Aloys, he would then comply with the statute, put his reasoning on the record. And I think also I would hope
Can it go back to Justice Aloys, or does it have to be done at the appellate division?
Well, I think that the new securing order would be before Justice Aloys, because if this court were to, you know, grant the writ and release him, then there would be no valid securing order in place, and I think the people would then start over.
But under B, I think it would be back before the appellate division. Do you agree with that?
Yes, I think under B, it would be back before the appellate division to develop the appropriate securing order.
And why can we not, or should we not, take into account whatever else had transpired and conclude that implicit in the statement from the judge is an understanding of not the fact of the vacated conviction, but all of the evidence that had come in at trial and so forth?
For 2 reasons, Your Honor. The first reason is that the statute doesn't allow for an implicit determination. It uses a lot of words. It says explain the basis of the determination and the choice. It says it over and over again throughout the statute. That does not allow for us to assume that the judge considered the right factors. And the fact that he presided over the trial doesn't mean that Justice Aloys is
Well, we do
exempt.
have the prosecution's, the people's argument, which was before the judge. How come that isn't something we can account for at all?
Well, again, the statute doesn't say the record should reflect. It says the court must give an explanation. And secondly, because There is nothing that happened at this trial that would justify this. I mean, the people concede that all of the evidence is going to be the same. This is a computer-based case.
However, there is something that's different. The defendant was convicted at the earlier trial. It was reversed, but there was evidence presented. He knows now of a likelihood of being reconvicted. Would that not impact one's flight risk?
No, so I respectfully disagree. I think Mr. Guerra was well aware of all the evidence before the first trial. All of this evidence was known from
No,
the
he wasn't
beginning.
aware of what a jury would determine after that evidence was presented.
Well, he's not aware of that now because he never had a trial where that evidence was put through the adversarial testing that the Constitution requires. So the fact that he was convicted once after a trial where he was failed by his counsel, by the court, by the prosecution, who told the jury that they should wonder what Mr. Guerra hadn't told them, the fact that he got a conviction...
So you're saying because the first trial was flawed, one cannot consider that the defendant might take into account the chances of being convicted again when assessing flight risk?
Right, I think because we're looking at this from Mr. Guerra's perspective. From Mr. Guerra's perspective...
No, that's what I'm asking you. You're
Right.
saying the fact that he was convicted before, that is not to be considered from his perspective.
From his perspective, no, because he has just won his appeal. There's no reason for him to think that now that he's finally going to get the trial that he deserves, that he would fail.
Is that a per se rule? Over here, sorry. Is that a per se rule?
No, I don't think so. I think that that's particularly...
Turns on the grounds for a reversal?
I don't think it turns on the grounds for the reversal. I think it turns on what the evidence is in the case. This is a purely computer-based case, so it's not as if there's going to be a really compelling complainant that's now going to testify at the next trial.
You're not, if I understand you correctly, sorry, we're here, you're not saying that had Justice Alloys made a determination on the record and said one of the factors is that there was evidence at trial that I considered, and that makes me think that there's a greater risk of flight here, that might not be sufficient. I thought your problem is that he didn't say anything, and so we don't know whether any of this affected him at all or even thought about it.
That's exactly right. I think if Justice Alloys had said what Your Honor just said, this would be a really different case. I still might take issue. I still might think it's abuse of discretion in terms of how he weighed it, but I don't think we would have an illegal securing order.
You wouldn't be under A in any case.
Exactly.
And
That's
so
exactly-
you're not, sorry, didn't mean to interrupt you, go ahead.
I lost my train of thought, so.
Okay, well, my apologies then. So you're not arguing that where you have a conviction that is vacated, that anything that transpired in the first trial is beyond the court's consideration as a matter of law. You're not suggesting that.
No, not at all. What I'm saying is that those facts, those things that have transpired have to relate to risk of flight. But what the people are said here, and I think we should take them at their word from the bail hearing, they say you should remand him because of the disturbing charges he has been convicted of. So it's the fact of his conviction alone as a standalone basis for remand that I think is the constitutional problem. And in fact, taken to its logical conclusion, I think...
Well, when you say a constitutional problem, I thought you were making an argument from the statute.
I'm making both. I think that the statute here has been violated unquestionably. I think it is also a constitutional violation to incarcerate someone simply because he has a conviction that has been now reversed.
And why is that exactly? Is it because it burdens the right to appeal in your view, or some other reason?
No, because a reverse conviction is a nullity.
Is no basis.
Yes.
But what if it
And
was...
the evaluation that the jury has made, let's take a different case. Let's take a case where there's not the sort of problem that we have here, but there is some other basis on which a conviction is vacated, which doesn't really go to the way in which the jury perceived the evidence. In your view, could the fact of the conviction, by which I mean the defendant's understanding of the way the jury processed the evidence, could that be something that the judge could take into account, because the judge would conclude the defendant thinks that the same result is likely the next time around?
I think possibly, yeah. I mean, I think if this was something like, the right to a public trial was violated, something that
Yes.
was really and so nothing was going to change, then I think possibly in that situation, the court could take that into account with respect to flight risk, and then I think the court would really need to put that on the record, and that's what we don't have here. He's imposing the harshest possible securing order. He's rejected all of the alternatives under the new bail law, all the non-monetary conditions, and we have no idea why. And I think had Justice Alois given that, even that explanation, it would have gone a long way to ameliorate.
I'm not sure in this, I'm not sure that he actually rejected all the considerations under the new bail law, because it appears that he cited the old bail law, and he may not have recognized that there was a new bail law in place at all. He cited the old one that was no longer on the books at the time he made this determination.
I agree, and in fact, he says the factors in 51030, and actually the factors used to be in 51030 before the bail law reform. So I think what little we can glean from this record is that he was applying a pre-2019 framework.
He was applying what the legislature wiped out.
Exactly, which again just supports that this is an illegal securing order.
But those considerations, as opposed to perhaps the failure to give an explanation, they might go to an abuse of discretion, no?
I think when you have an absolute failure to establish any lawful basis to detain, that is actually, we're in Section A. That's an illegal detention. I think that's particularly true when we're talking about remand and we're talking about a change from the monetary bail that was set before the first trial. The equivalent to the monetary bail in the first trial now under the new bail law would likely be, release with some non-monetary conditions, or release like the CJA recommended before the first trial. Because when we look at this record, Mr. Guerra isn't any kind of flight risk.
Counsel, I'm sorry, your light's on. Just quickly, I do see a few appellate division cases, habeas, where that court remitted, where there was an insufficient record made by the trial court in similar circumstances. Would you say those cases are wrongly decided, or wrongly disposed of, or distinguishable?
I would say that those cases, without remembering the facts of them, it's hard to distinguish, but I would say that I think that is the wrong result, because I don't think the habeas statute provides for that remedy. I mean, look, habeas is a very blunt instrument. Illegal detention or no illegal detention, and if it's illegal detention, release has to happen. There isn't really any provision within this statute that allows for remand. I see my time.
Can I,
I'm
I'm
sorry.
sorry, no.
The appellate division couldn't say it's unclear whether there's illegal detention? What if it's unclear if there is? What do you do? Then you just detain? It has to be clear?
Well, I think if you have a situation where it's unclear, I think you're probably in abuse of discretion land, in which case the appellate division fashions the appropriate securing order.
If I could just want to be clear on your argument, perhaps I'm misunderstanding you. Is your argument that the judge fails to explain what he means by assuring the return to court, defendant's return to court?
Yes.
Or are you saying that even that is not enough?
Oh, I think that even that is not.
Well, I'm sorry, not enough to make clear that what the court was focused on was whether or not the individual was a flight risk.
Yes, I think it's the latter, in the sense that the court didn't explain the basis of its determination that he's a flight risk. It didn't apply the flight risk factors.
Do you agree
to-
there's a determination that he's a flight risk?
I'm
You're not
not
challenging that.
sure.
Perhaps I'm not being clear.
No, I think I am challenging that. I don't think there's an indication that the court even made that first step.
Well, what could it possibly be referring to? That the
I-
least restrictive the court finds that the least restrictive means of assuring his return, or doesn't find, assuring his return to court is in fact continued remand.
Well, I don't think the court really gave the analysis the full.
No, I understand the rest of that, but
No, right.
isn't
I'm
the
saying
whole
with-
point of saying that the court finds that the least restrictive means of assuring his return to court is in fact continued remand, meaning that the court has concluded he's a flight risk? Might not have explained why. I get that part of your argument, but I'm not sure I fully appreciate, if this is the argument you're making, that even the little that the judge says is not enough to conclude that the judge had decided Mr. Guerra was a flight risk.
I will explain very quickly. I think it is because there is no individualized determination here on the record that he's a flight risk at all. It's almost as if the court just assumed it without undergoing that statutory requirement to determine whether that's true, and then just jumped right to this boilerplate generic explanation that could have applied to any defendant that walked in the room that day.
What is it about the statement that leads you to that conclusion? What is it about that it doesn't show that there wasn't some evaluative process that took place in the judge's mind at the time he said that?
Well, for starters, he's citing the wrong statute. He's citing the wrong standard. He's not applying any factors to Mr. Guerra specifically.
No, he's not showing his work, but you said that that somehow betrays that he didn't apply the statute at all with respect to the limited question that you were just asked. Not that he failed to explain it, that's a given, but why does that indicate that there was a lack of process in the judge's own mind about that?
Well, I think that goes to the very purpose of this requirement. We don't know what's going on in the judge's mind. That's the problem. And
So you're saying that the judge has to show her work?
Yes, I think that the legislature is very clear about that. Repeats it over and over again. I'll reserve the rest of my argument for rebuttal.
Thank you.
Good afternoon. Nancy Fitzpatrick Talcott from the Office of Melinda Katz, the District Attorney of Queens County. The Appellate Division properly dismissed the writ because the defendant was not illegally detained, and the lower court did not abuse its discretion in remanding the defendant. The court expressly stated it had considered all the factors in the statute.
In the wrong statute.
Right, although 51030 incorporates 51010 by reference. So if the court misspoke, it was clear it did consider the factors in the statute, and that's likely why defense counsel didn't object or ask for clarification.
But how is it explaining the basis?
Well,
That seems to me to require something more than asserting the conclusion, which I think is all we have here.
well, so yeah, just to conclude with the first point, he found the least restrictive means of assuring defendant's return was remand.
And that's the conclusion.
That indicates the basis for the decision was defendant's risk of flight. Now-
Okay, first of all, why is that? Why is that evident from that statement?
Because assuring defendant's return indicates there's some indication that he might not return.
And then
That's a risk of flight.
how does that sentence explain the basis for that conclusion?
Well, I think where the court's reasoning was evident, given the arguments that were before it.
So you're saying that it's implicit, given what the judge has heard, and the judge doesn't have to make explicit the actual basis. Is that right?
Well, I think the court should be able to rely on arguments in front of it.
But then
So-
why doesn't the court say that? Based on the
Well-
people's argument, I am persuaded, et cetera, et cetera, et cetera.
It certainly would have been better, but it can observe the statute based on the arguments before it. And the arguments,
Does the
Well, it
statute
could have,
say
but we
that?
don't know. Could have, but we don't know, right?
no.
And does the statute say that?
Well, the statute doesn't require a catechistic,
No, but it says explain the
Citation.
basis.
no, right, but where the record makes obvious the reason, whereas here it does, based on the people's argument,
But it doesn't say the record shall reflect, or it doesn't say the judge shall determine, which might be a better case for the sort of, reliance on the record point that you're making. I'm just trying to understand how we give meaning to the words explain the basis if we conclude that looking to the arguments made to the judge, and there may be countering arguments, and I would think in most cases there will be. I'm just not sure how we get there.
well, the two lower court decisions cited in our brief, they say where the record makes it obvious the reasons for the decision,
Yes.
a short
But why
and
does that
concise
comport-
explanation should be sufficient.
Right, but where is there any explanation here? I'm not suggesting catechistic or long, whatever, but where's there any content? I take it you're saying that there doesn't need to be, it can simply be that there have been arguments made to the judge, and the flat determination is sufficient to essentially bootstrap those into the judge's conclusion.
Well, he did reference the factors. The factors were the subject of the arguments, the people's,
He said he had considered the factors.
right, and the factors the people set forth unquestionably were factors that were relevant to a risk of flight, which the court made clear was the basis for its decision.
Can I ask you a different question if I can? I didn't see a lot in your brief on this, and I would welcome your thoughts. The distinction between 710A and 710B. I understand your view is that the explanation was sufficient, but what about the difference, if you would?
Well, I think a flaw in the process, which is arguably what we have here, doesn't mean the detention is illegal. So,
Well, your adversary says, I think, where there is no explanation given, the predicate has not been met. So why is that not right as opposed to it being an abuse of discretion?
well, there's a difference between the procedure being flawed and the result being illegal. For example, if this was if he was charged with a crime that was not qualifying, that would be illegal. What we have here is a flaw in the process. So again, to touch upon what the judges brought up with my opponent, the remedy would be you can send it back for clarification. And the appellate division recognized, because we're reviewing that decision here, a more complete record would have made its decision less difficult. But in the end, it obviously concluded that the record, albeit not perfect, not as comprehensive or exhaustive as anyone would like, it was sufficient to conclude that the lower court's determination did not violate constitutional or statutory standards. Because the bail court's
If we agree with you, doesn't that incentivize judges to do exactly this, even though you yourself are saying, well, it'd be better if they actually explained their analysis? Maybe the judges would cite the right provision, but that's another story. And is that the way we anticipate the legislature intended for these decisions to be made available for appellate review?
Well, the courts could certainly give guidance in this case.
In what
or-
context? I mean, I think part of the problem here is, I feel like habeas is the only vehicle for us to give that guidance, right? This could not be the subject of an appeal, could it?
No, habeas, we never argued that habeas wasn't the right vehicle, but again, you can.
No, but if we want to enforce the notion that you really do need to follow the requirements of the statute, what you call a process error, we have to do it within the confines of the relief that's afforded by habeas, which potentially could be simply release, although I heard you argue that maybe there are some instances where it could be some sort of remittal. But this is really the only place where we can do that, right?
Right, or you can send it back with a directive to the appellate division. Perhaps hold the writ in abeyance or conditionally grant the writ until the court explains it. Then we get guidance, you know what, this isn't enough. You have to say more.
You know, what I'm struggling with here to Judge Canataro's question is there is no explanation on the record. There's a statement that the judge considered the factors and reached the conclusion, right? So if this is not a case where the judge gives a conclusory explanation and we're being asked to say, well, are those two sentences good enough, right? So if not in this case, where would we conclude that explain the basis was not met?
I think, for example, if the court had just said remand. Even worse, I think if you had
Well, how is that meaningfully different in terms of explaining the basis? I mean, explain the basis, I guess, under that reading would simply mean I consider the factors remand.
But in my example to you, which perhaps an example where it would be warranted, is if he just said remand.
Okay,
He didn't
but
mention the factors.
then we'd have to decide that I consider the factors remand is acceptable, but remand alone is not. I'm just not sure that does a lot of work in terms of explaining the basis.
No, but you have remand plus the factors affecting flight that were put forth before the court. For example, so an even worse case
But
scenario.
the problem is, we have no idea, because the judge chose not to explain the reasoning, if the judge agreed with everything the prosecutor said, or took a different view of some of it. That's the problem, isn't it? Even if I could see my way to this argument that, well, you just look at the arguments and that will somehow give you some insight into the judge's analysis. But here, there's no way you can do that.
Well, you can infer that he adopted or agreed with the people's arguments, which again were unquestionably factors that related to flight. And it would be an even worse case scenario.
What were the
had
arguments?
there
Just
been-
quickly, I don't want you to waste too much
Oh.
time on it. What were the arguments, as you view them, that the
The
judge relied on
seriousness-
that were made?
The
Go ahead.
seriousness of the charges.
Right.
The strength of the people's appeal, the strong evidence in the event of a retrial, and the severity of the sentence defendant continued to face. Those all
What if he rejected 3 of the 4, and the one he relied on, this court might say you can't rely on?
well, then
We don't know.
right, so then the remedy would be back to send it and get it clarified. Because again, perhaps the worst case scenario than him just saying remand is no arguments, and he just says remand. That's
But-
far
but
more of a
still,
I mean,
problem.
if there were no arguments? Sorry.
But still, there's a responsibility of the court to explain on the record or in writing its reasoning.
Right.
And you're asking us to infer what that reasoning is?
Well, the court, again, should be able to rely on the arguments before it.
We're not saying that
Yes.
he's not, but did the court say that or put that in writing? That I'm relying on, and as Judge Rivera just said, prosecutors can make a lot of arguments, but the court need not adopt all. But is it not important to know what it did adopt and what it did reject in order to determine if it was an appropriate decision?
Well, if that's the flaw here, then it should, that doesn't result in that the detention is illegal.
Okay.
That means it should be sent back for clarification. And this court doing so would give guidance in that respect.
If you went to DA Katz and she said, explain your reasoning for how you're coming out to this result, and you said, I complied with the law and left her office, do you think she'd be satisfied?
Well, I would like to think I would give her more.
Exactly the
That's the
point.
point.
But again, I would repeat the arguments put forth before the court and just hopefully explain it better. But again, the appellate division recognized wasn't the greatest record, but it still found, at the end of the day, it was sufficient to find that the lower court didn't abuse its discretion. And because the bail court's decision was supported by the factors, viewed together, the decision to remand rested on a rational basis. That's beyond correction in a habeas. So the appellate division's decision was proper. Defendant wasn't being illegally detained, and it correctly...
Let's just say we disagree in terms of your argument of why we should uphold the appellate division, but then the remedy, in your view, is to do what? Hold the habeas in abeyance? What's the remedy in your
I
view?
think this court could have several options, perhaps send it back to the appellate division, directing it to hold it in abeyance.
That's what B instructs, if that's the provision you would suggest we would proceed under, right?
Or conditionally grant the writ until the court sets forth its reasoning. You could direct the appellate division to do that as well.
Thank you.
But just briefly, in any event, the factors the court considered, it is proper to consider the first trial. The defendant was not in the same position as someone awaiting a first trial. The court and the defendant were fully aware of the strength of the evidence against the defendant and the potential sentence he faced. Proof of guilt was fully elicited. The witnesses were cross-examined. It's largely digital. It's not going to be a case where a witness, has some discrepancy or, second guesses their identification or anything. The
Is there a
witnesses-
preservation issue here?
With regard to,
Was there an objection made as to the sufficiency of the reasons that the judge set out?
I mean, they objected to the remand. Is that what you're asking?
Yeah, specifically as to the fact that there were no reasons set out.
And that was my point with, that the court presumably misspoke when it cited the wrong statute, that he never said, well, Judge, there's no factors listed in 51030. You're not setting forth what you're relying on. No, there was no objection in that regard. So he's not in the same position as the first trial. So the court properly considered part of the history was this conviction. Not the fact that he was convicted, but what that meant. We had a first trial. The defendant was fully aware of the magnitude and strength of the people's case. Not so when you're awaiting a first trial. The court could consider the charges, including the nature, the seriousness, and the sentence. That doesn't impact the presumption of innocence. The court can consider the strength of the people's case before the first trial. The fact of the criminal conviction is properly before the court for consideration. That's not to say it should ignore that the case was reversed. It was fully aware of that. But keep in mind, it was also fully aware that the appellate division, the majority and the dissent, 5 judges found that the evidence was legally sufficient and that the weight supported a verdict of guilty. The court was well aware of that. The court could also consider the charge is alleged to have caused harm. While the defendant's crimes are D nonviolent felonies, they stem from heinous crimes. And defendant's crimes result in the market for those underlying crimes to continue. And that harms untold numbers of babies, toddlers, and children who are the subject of these videos and images. And the court could properly consider that. And in the case of an application for a securing order, the pending appeal is not limited to a defendant's appeal. Nothing in the statute restricts the court from considering the people's appeal. And that was put before the court. And the strength of the people's appeal, there was a strong dissent. It was 3-2. The court was fully familiar with the issues upon which the case was reversed and the other findings in the decision, and it could properly consider that. In the end, the appellate division properly dismissed the writ. The defendant was not being illegally detained, and the lower court did not abuse its discretion in remanding the defendant. If the court finds the records insufficient, the remedy is not release. It should go back to the appellate division to direct the trial court to make a more sufficient record.
Thank you.
The charges and the strength of the case, those are all the same in 2017, and yet the people offered a 1 1/3 to 3-year plea deal to Mr. Guerra for these D nonviolent felonies, a plea deal that he rejected because he's so adamant about clearing his name. This is someone who surrendered voluntarily for questioning. This is someone who has never absconded, who has no criminal record. This is someone who has just won an appeal and will finally get the trial that he is entitled to. He has.
But there's also the fact, that just because you win an appeal, unless the conviction is, unless it's said that there can be no retrial. Retrial presents a possibility of another conviction, does it not?
Right, well, any time that the court.
And are you suggesting that a court cannot consider what the defendant's viewing? He's had a full, not just an anticipation of what the evidence may be. He or she will have actually seen it after that first trial, correct?
Correct. The problem is that any time the appellate division finds the evidence is legally insufficient or against the weight, they dismiss the case. So the only time you have a retrial is when you have had a reverse conviction.
And there's a likelihood that one can be convicted.
Sure, and I think that there is a big difference between saying, okay, the facts of this trial, what came out here, this is different. Now there's a testifying co-defendant, you've seen that, or whatever. Even if it's something like,
The prior conviction is something that is different from the first time that bail was considered. Would you not agree with that?
I don't agree with that, and here's why.
You don't agree that there was that information, that conviction wasn't before the trial court? Before trial?
I think that the evidence in the trial might not have been, but the conviction itself doesn't exist anymore. It's a legal nullity.
Well,
So
can I ask you this? What if it was another way? What if the conviction was overturned because a statement was let in that shouldn't have been let in, and that's the major evidence of the case? So now this statement is no longer going to be in front of the new jury, which was the most damning piece of evidence. You're saying that you couldn't go in front of a judge on a new bail application and say, Judge, their case has now just been significantly weakened, and I think my client should be out.
Sure, I think you could, and I think the reverse is true. If there was something that came out at trial that significantly strengthened the prosecution's case, I absolutely think the court could consider that.
You don't think a conviction by a jury and a reversal on a stipulation is something that the people can rely on to say that our case is basically the same but stronger, because we know that a jury has looked at this evidence, weighed it, and convicted him?
No, I don't think a conviction that is based on a trial where there was ineffective assistance of counsel, where that evidence was not subjected to adversarial testing, I don't think that that conviction should hold any weight in a
That
flight risk
conviction, that
analysis.
conviction's on appeal, right? Leave was granted, and putting aside the merits of that, but if this went back, could the trial judge consider that fact that that 10 to 20-year sentence is now on appeal to this court in determining what conditions were appropriate?
Yeah, well, he's already served almost 10 of that 10 to 20, so if he goes back, he's imminently
But could they
eligible for
consider that or not?
Yeah, what I'm saying is I think that you could consider that, and I think it weighs in favor of release because he is very disincentivized to hurt his chances at parole if he absconds. So actually, a defendant who has their whole sentence ahead of them is probably more incentivized to flee than Mr. Guerra, who has served almost the entire thing. I think also in terms of the strength of the people's case, you know, I don't think it's as strong as people think it is. The jury's deliberating, they're asking, are they bound by this stipulation? If they were accepting all the evidence wholesale, they wouldn't be worried about being bound by the stipulation if they had rejected the defense. And I don't think, in wrapping up, I don't think that when there has been a statutory violation here, which there has been, that the appellate division is free to just dismiss the writ. The writ has to be granted. Mr. Guerra has to be released for all of the reasons I've said, whether or not it's because we're in Section A and there's a per se, or we're in Section B and the court abuses discretion. Either way, I would urge this court to order Mr. Guerra's immediate release. Thank you.
Thank you.